Thank you, Ms. Sohn, and again, thanks for being here. I do think that the timing of the recusal after the hearing made it something that we should talk about and certainly support, again, you being here and your willingness to do that. Let's just dive into some of this specifics. You were on the board of this company, correct? But you didn't negotiate the settlement.
No, I did not. It was a nonprofit corporation, and I did not negotiate the settlement. It was negotiated by Sports Fan Coalition New York. I was never a party to the litigation. And from the very day I joined that board, because there was something called a case narrowing agreement, which I'm happy to talk about, I was never financially on the hook for a dime.
Okay. And as far as the timing of how and when they negotiated, you also had no knowledge about that? And was that driven by a court process where the court had outlined this was now in a negotiated settlement, and so the court had said we want a timing of this negotiated settlement by a certain date? Right.
So the court entered an injunction on September 15th, and we had 30 days to decide whether to appeal or to settle. And obviously, I was involved as a board member in the decision to settle as opposed to appeal. And I'll be honest with you.
By that you mean they consulted the board and the board had to sign off?
They said, look, you know, we're up against the four biggest networks. We're a tiny little nonprofit. We don't have that much money. Let's just throw in the towel. We lost. Let's just throw in the towel. And then we had 30 days from September 15th to either decide to appeal or settle.
So you had no control over that. It had nothing, your nomination of, well, let's just be clear. Someone had suggested that you might be, and they asked you if you wanted to be vetted, and you agreed, because why not? Why not be on the FCC, right? But that had happened months before.
Months before.
So you had no idea what was happening on either end. You didn't have control over the settlement, and you didn't have control over your nomination. The court was driving the settlement process. Let's get to this number amount, because as you said, you didn't mislead the committee on anything. You basically answered the question about the settlement, and you were constricted by what you could say. You were not supposed to talk about the details of the settlement. Since then, as you said, the information has been linked. But the point is that the court basically said, we're not going to find for low caste, and you guys should reach a settlement. The settlement agreement then basically put this stipulation in there, basically as a way to say to people, don't ever think about these ideas because we think that they cost us a lot. So that's their way of expressing their future incentive. But when it came down to settling, they readily agreed to settle on what they thought was the real impact. And so that is the difference between the number. Is that correct?
That's correct. So the judge never ordered $32 million in damages, okay? And let me clarify one other thing, if I may, Senator. Low caste was found not to have qualified for an exemption of copyright law. No liability was found by the judge. It was not found to have infringed anything. It was just found to not have qualified for a statutorily imposed exemption by Congress for nonprofits. So I think that's important. $32 million is what the networks could have sought in statutory damage. The judge did not ever say that low caste was liable for $32 million. But in the stipulation, again, in order to scare away the next low caste, the parties agreed to put in a clause that says statutory damages was $32 million. Now, what's really interesting about that is that the settlement agreement was already agreed to and signed by the time that stipulation was submitted to the court. So there was never a question about whether $32 million was the actual amount. The actual amount to be paid was always $700,000.
And again, you had nothing to do with that?
Nothing to do with that, okay. No.
And as far as your recusal, that recusal was about an open document issue. So in basically, you're saying, I want to be transparent. I want to make sure there's no issues. I was on the board of this company. And this company and this agreement in this settlement is related to an open docket that you had filed a letter on long ago in a previous capacity. So you wanted to make it clear to people that that open docket issue is something you're not going to go back and sit on the FCC and deal with. And so that is what your recusal states. Is that correct?
That's correct. I counted no fewer than 8 members of this committee expressing concern either in QFRs or the hearing about Locast. So obviously it concerned me that there was so much concern. So I wanted to address that concern by looking at the nexus of what I may have worked on before and this litigation. And I found this petition for rulemaking that I personally signed 12 years ago, and for which there was precedent. And I think that's really important. Chairman Kennard did the exact same thing. Now, he was already sitting on the commission, but I don't think that's a distinction without a difference. It's a voluntary, narrow, and temporary recusal. And it will have, in my opinion, and I'm happy to answer questions about this, very, very little impact on my ability to be a commissioner of the FCC.
Thank you. Senator Wicker.
Thank you, Madam Chair, and thank you, Ms. Sohn, for being here.